Hello, everyone. Sorry, I had a family emergency, so Margot and John are going to handle this. And feel free to put your questions in the Q&A box right now, and they'll get to them. Thank you. Have a great webinar, you guys.
Thanks, Michael. So I'll jump in and do a quick introduction. My name is John Roussas. For those of you who are joining us for our first webinar here together, we've done, I believe, 5 prior to today. Margot's joined us once previously. Margot Cutter is my business partner, and she works with us on these fire cases. She works with us on representing you, people burned out by the Palisades fire. We've gotten a lot of requests by folks to come on and give some additional information about what to expect with a civil lawsuit, timeline-wise, involvement, what you will have to do, what that will look like, how long to expect. So Margot is going to provide some information about that, and then we'll jump into question and answer. I know there are a lot of questions, specific questions that are ranging the gamut. So we'll just open the floor, put your questions in the Q&A here, and we will get to each of them. Expect probably about 40 minutes of open floor Q&A here after we talk about the procedure issues. So with that, I'll turn the floor over to Margot to address what to expect in a civil lawsuit timeline.
Thanks, John. And just to acknowledge that someone did put a test question in the Q&A box and we did receive it. So that is functioning. Well, happy to meet everyone that's new here. And let me go ahead and share my screen so that people can see kind of this handout. Can you see my screen?
Can see your screen.
I know the font is tiny, so I'll zoom in, but this is kind of just a general overview of what to expect in civil litigation. So once you file a civil lawsuit, what is kind of the general process that happens? So kind of starting out, the first thing that happens is over here on the left, right? A lawsuit is filed, and I'll zoom in so people can read. First, the lawsuit is filed, and that needs to be done within a certain amount of time, called your statute of limitations. Sometimes people call it being a complaint being filed, and that just means that's the name of the legal document that is filed to begin your lawsuit and open the litigation. Once the complaint is filed, then we have someone, a third-party person, serve it on the defendant. So the person that did something wrong. As soon as that complaint is served on the other side, then something called discovery can begin. And discovery is really the beginning of the mutual exchange of information between the parties regarding the circumstances and facts of the case. So anything regarding kind of on the defendant's side, what they did, what they didn't do, their policies and procedures, the choices they made that got us here. And then on the plaintiff's side, all of your side, questions regarding your property and the things that you lost and the injuries that you and your family suffered. And all of that will be at play in discovery for the parties to learn about each other and the facts and the damages and the injuries that everyone has suffered. So after the complaint is served, the next thing that happens is the defendant, I mean, here usually a utility company, will file a response of pleading, and they'll answer, or they'll try and get the court to dismiss the case initially. So they'll appear in court and respond somehow. And that's usually when those first initial written, called written discovery, those written documents are exchanged. And those are, they look like legal documents, but it's just a list of questions. And for people that we represent, we help you answer those questions, because a lot of times there are legal objections that you have to do in responses to the questions, and then we'll help you formulate an answer that captures, the facts and circumstances while also making sure not to hinder your potential for recovery. So the written discovery process can be long. In a typical case, it lasts for the duration of litigation, really. So it can take years, really. Sometimes it's as short as a year if a case gets to trial really quickly, but it's often a years-long process where multiple rounds of written questions are exchanged back and forth between the parties to gain an understanding of what happened. So form interrogatories, those are something where the court has some kind of generic questions that are often exchanged. Then they can ask specially formulated questions that are tailored specifically to you in your case. And then they can ask for documents and things like that. In these cases, they'll be looking for receipts, all sorts of documents regarding your assets, your property, things that were lost, and any evidence you have of your possessions, really. And then in a normal case, and in the fire cases also, the next phase of litigation after that written discovery, which takes a long, long time, is depositions. And in the fire cases, I expect that many more depositions will be taken of employees at the different entities that are potentially responsible. And John is going to get more into the specifics of what to expect most likely in this fire litigation, but often in regular litigation, also the plaintiff's deposition is taken. I don't think most people will have their deposition taken in the fire litigation, but the deposition process is really where a person is brought into a courtroom. There's a court reporter present taking a perfect transcript of everything that's said, and it's under oath. So it holds the same significance as if someone were testifying in a court of law, but it's in the informal setting of a conference room. And it's really the attorney's opportunity to ask the person questions and kind of hear the person's answers straight from the horse's mouth. Because all of the questions that go back and forth in written discovery, everyone knows that those are going through the filter of a lawyer. And so when you get to deposition, it's your first opportunity to really hear from the person and hear their unfiltered response, that's not being screened through their attorney. That's not to say if it does occur that your deposition is taken, of course, we work with our clients to prepare them for that and practice before their deposition is ever taken so that it's not a new or scary or unfamiliar experience. But I don't think that will be at play for many, if any, fire victims. Okay, and so the next thing that's kind of at play are these case management conferences. And that means that throughout the litigation, and especially in the fire cases, a judge will hold conferences with the lawyers. Usually victims and the parties don't appear and don't come to these conferences, but the judge will check in with the lawyers to make sure that the case is going well and that the court is satisfied that the parties are moving it along and are proceeding to trial or working to otherwise resolve it. So the parties, the groups, the individuals who are harmed and the entities who are responsible will file with the court case management statements where they indicate their positions, and then the court will review those and hold hearings with the parties to make sure that everything is going well. Then as the case kind of proceeds, we enter this phase of expert discovery. And expert discovery will be happening more and earlier on in the fire cases, but really it's when people who are experts in their field, and here people who are experts regarding fire, what could have been prevented, what went wrong, choices that were made, down to the minute and hour of things. These are experts that will come in and testify at court ultimately about what happened. So first the parties tell each other who each other's experts are, then the experts are deposed and give their opinions, and then ultimately, after the experts are deposed and their depositions are taken, discovery is done, and the case goes to trial. Now, as you can see, at any point in this timeline, the parties can mediate the case. So that means throughout the whole lifespan of the case, the parties will be working to settle it, to resolve it, to see if we can come to some kind of agreement. So at any point along this timeline, the case can resolve. Usually it doesn't happen super early on over by the complaint side, but after that, it's really anyone's guess when it can resolve and through what means. And so then the ultimate final decision, if the parties can't come to an agreement, is that the case will go to trial and a jury will decide what's fair and right. So that's the general litigation process.
Thanks, Margot.
Yeah.
So what we wanted to do was first start by outlining the general civil litigation process. So you have kind of an A to Z view of the lifeline of a civil case. And now jump in and talk with you about some of the modifications that are made for fire litigation. So in fire litigation, most of the people who are impacted, such as yourself, typically handle their part of the case in writing. You will not typically attend a deposition. The cases will resolve without your deposition being taken. What you will do instead is you will fill out written discovery. You will fill out written questions and answers. What did you own? What was destroyed? Where were you when the fire occurred? Where did you evacuate to? These are questionnaires that your law firm will work on with you, and then we'll provide the other side the information they need to evaluate the case. I know that's one of the biggest concerns that folks have is how time consuming is it? You know, I've already put in so much time with my insurance company. Can't we just use that information? Can't we use the documentation I've submitted to the insurance company? And in many instances, the answer is yes. We will be getting the documents from the insurance companies, and we will be producing them to the other side, including the inventories that you have put together. And so that answers most of the questions. Very often, people find, though, that they need to supplement the list. You know, you had, say, $1 million in property insurance, so you put together a list with $1 million worth of property. But now you're in litigation and you want to recover the other $1.5 million in personal property that was destroyed. So you work with us, you coordinate with one of our vendors, and you prepare a supplemental fuller list of everything that you lost in the fire, and you provide that to the other side. As we've discussed in some of these other webinars, you know, the vendors that we work with have Excel spreadsheets with all of the typical contents of a typical home in America, and they're able to quickly upload things like knives, forks, silverware, all the small things that add up to a lot of money, but that may not have come to front of mind to you, for you when you're initially putting together your list. They can put all that stuff in for you. They take care of the valuation of your property. So it really decreases the burden on you as far as being involved in the case. Where these fire cases really focus and where they go heavy is on that portion that Margot was talking about, the discovery with the other side. That's where we are able to take the depositions. We're able to get representatives of the governmental entities, of the utilities in a conference room and ask them questions under penalty of perjury. It's a really uncomfortable process for them because they have to answer our questions and own up to their complete ineptitude, the reasons that they made the decisions that they made that burned the Palisades. And so it's a very uncomfortable process for them, and they don't have good answers. That's where we get the information that we need to get these kinds of cases resolved. That deposition process can go on for months up to a year. But that is where these cases are won. And that is all exclusively work that is done at the attorney level. The next thing that happens as that discovery process is unfolding, right? We're giving them information. Here are the losses. Here are the harms, so that they can evaluate and get a good sense for, here's how much we're going to have to pay. That is going on at the same time as we're taking evidence and we're getting evidence from the other side about their inability, their ineptitude, their terrible decision making that is responsible for those harms and losses. So that information is coming out simultaneously, and we're meeting with the court. The courts are very stringent on the parties. They insist that these cases move forward. They insist that they move forward on an expedited timeline. For example, in the Maui fires that we are representing many people in, the judge has been pedal to the metal and has insisted that work that is typically done in 2 years was completed in 6 months, 7 months. And we expect it's going to be much the same process here in this case. And so that the judge is already exercising oversight. We have a governing document in place. It's called a case management order. We've got that governing document in place, and it's sequencing, it's forcing the attorneys on the opposing sides to coordinate. There'll be motions where the liability issues are addressed. You've seen in the news, for example, that the DWP is saying that, hey, we can't be held responsible here because we didn't have a contract to provide water, right? And you've seen the headlines, it's a 110-year-old case that says that they can't be held responsible. That's where the judge is going to hear and address that issue. Personally, it is our view that the California Supreme Court in 1972 put an end to that nonsense argument that is being advanced by the LA DWP and its attorneys. This isn't a government tort claim case. This is an inverse condemnation case. That 110-year-old case, the Niehaus brothers versus Contra Costa case that they're citing to and talking about, it's got nothing to do with you. It's psychological warfare that's being played on you by the government and its attorneys. It's wrong. It's completely out of place with the facts of your case. And that's where the judge will address issues like that. And then you can see as all of these things are coming together, right? The legal issues being sorted out by the judge, the evidence coming in through the witnesses, you simultaneously producing information, answering questionnaires that allow the defense to see exactly how huge the ticket is, the price is for what they have done. As all of this information converges, you much more quickly come to a place where your case can resolve. The judge can hear dispositive motions. Dispositive motions are the ones where the judge decides, after all of the evidence is in, after all of the witnesses are deposed, the judge decides, is there some legal reason that this case cannot go to trial? And that would be kind of the final hurdle before we get to go to trial, and we get to have our day in court, and we get to put on our evidence and hold them accountable in a public setting. So that's the civil timeline as outlined by Margot, with kind of the additions, changes, and modifications that apply for a fire case. And as I promised, we try to keep that to about 20 minutes so we could do about 40 minutes of open floor question and answer. So Margot, since Michael's not able to moderate that, would you mind running the Q&A?
Yes. Okay. So we do have a few questions. The first is, Altadena residents who lived west of Lake Ave did not receive the fire warning. do we have any legal recourse against the party responsible for sending out the notifications?
Yeah, that will be a part of the case. This is sadly something that that was part of the Maui fires. It's part of the Eaton fire. Short answer is yes, but what that recourse is really depends on your independent facts and circumstances, what the consequence of the failure to give that warning is.
The next question is it worth it? Is it going to take 10 years? People know they're looking down the pipeline at a long haul, maybe, so they're wondering if they should bother.
Yeah, so first, I'd address the 10 years question. It's not going to be 10 years. We don't know how long it is going to be. We can analogize to other fires. The North Bay fires where it went through bankruptcy, that was a 17 fire. It's now 2025, and almost all of the funds were paid out in the first 5 years. We're now getting to the place where the last of the funds are being paid out. But even with a bankruptcy, the funds have been paid out in less than 8 years. So there's no reason that this case would take 10 years. How much less than that? Nobody can promise you that. No one can give you a definitive answer to that question. It could be a Maui fire, which is within a year. There was a framework. Within 2 years, we're going to be on the verge of issuing the first set of payments in that case. It could be somewhere within that continuum. Anybody that gives you assurances that they know what the answer is to that question, I'd ask them a really sharp set of follow-up questions, but I would expect that this is closer to a Maui than it is a North Bay fires. And is it worth it? To answer the second part of the question, yeah, that's a question that only you can answer for yourself. For us, when we went through this with the North Bay fires, absolutely no question, no doubt about it, 100% worth it. We had absolutely no intention of allowing PG&E to not only burn down our family home, but then get away with it. So for us, it was absolutely worth it. In your own circumstance, is it worth it to you? Is it going to help you to walk away from it? Is it going to prevent this from happening again by walking away from it? I don't think that that's the case, but that's really something that you can only answer for yourself.
And kind of a subset of this is folks are wondering, what are the chances of being made whole and what is considered being made whole? So, our property damages award offset by the insurance payout?
Yeah, so first, the chances of being made whole, better chances than not filing. So short answer is you have much better chances of being made whole by pursuing your rights, by insisting that the wrongdoers be held to account than by doing nothing, by walking away, by letting them get away with it. Then, once you get into the litigation, there are very good chances of being made whole. What does it look like? What does it mean to be made whole for you? It really depends on your individual facts and circumstances again, right? If you had good insurance and most of your losses were paid for, then you stand very good chances of being made whole. And being made whole, it means exactly like what it sounds, right? It is having all of your personal property, all of your real property, all of your business losses reimbursed. Your emotional distress, the impact on your quality of life, the loss of your neighbors, your friends, the community that you built over all these years, that will be a part of the case as well. That will be something that is compensated as part of the litigation.
Michael, you've unmuted yourself accidentally. Michael's having a family emergency. Michael, if you can hear us, you're unmuted. Okay.
Oh, sorry.
All good. Okay. The next question is, in an inverse condemnation claim, if you receive insurance for contents and for dwelling sufficient to cover loss, is there effectively no claim?
So if your insurance has compensated you for 100% of your property losses, then you're one of the blessed few who are in that circumstance, and you don't need to pursue a lawsuit to be reimbursed for your property losses. There are two parts to the lawsuit that we are pursuing. The first part is inverse condemnation. That is, if this ends up being an LADWP and exclusively for the policy decisions they made that resulted in there not being sufficient water to fight the fire while it was smaller and manageable and could have been managed, then it's inverse condemnation and it's only your property losses. If it turns out that what we were also investigating, which is the second utility ignition, also was a substantial factor, meaning more than just a trivial contributing factor, then it's all losses of all kinds that you've sustained that we can get you compensation for. That's your personal property, your real property, your emotional distress, your quality of life, your the stress, the anxiety, everything that you're dealing with now as you're trying to rebuild your life. That will also be compensable as part of that lawsuit. So whether your insurance has paid you for all of your real property losses, your personal property losses or not, it makes sense to get involved because the statutes of limitation are coming up. And that means you have to make a decision. You have to get involved. You have to pursue your legal rights, or else they go away forever. And if we can recover for you both under inverse condemnation and for the utility second trigger of the fire, then and you do not get involved, then you lose those additional rights. So get involved. Reach out, whether it's to my law firm or somebody else, if we're not your particular cup of tea. Protect your legal rights.
The next question is two parts. First, what is the law firm? John and I work at Cutter Law, and we're partnering with Mychal, who is in LA and has his own firm. John initially got involved doing the fire cases when they began up north and his family's home burned down. And then since then, we've been involved in many fires, including the Maui fires and now the LA fires. My uncle's home burned, and we've had a lot of friends and family affected. So we really feel for all of you, and our firm understands the gravity of the situation. The next question is this a mass tort case?
Yeah, so what mass tort really means is it's a two-word way of summarizing when a large group of people are impacted by the same set of facts and circumstances, and they come together, they pool resources, they pool knowledge, and they pursue their common interest against those responsible for their common harm or loss, right? And so here there are many people, so there are many plaintiffs, mass, in other words, plaintiffs pursuing and vindicating their rights against those responsible for causing their losses. So yes, mass tort is just a shorthand way of saying the people responsible hurt a whole lot of people by doing the same stupid things.
But everyone will get different amounts of money at the end.
Yes. And
not like a regular class action case.
Yes, and that's what distinguishes this from a class action. And that's something that for some of you, you've seen in I believe it was webinar number 4 that we did, distinguishing a class action from a mass action. Class action is more of a cookie cutter, one size fits all. The claims are not personalized. In a mass action, your individual rights, your individual harms, your individual losses are represented. You are an individual being represented. You are not part of a class where somebody else decides what your harms are. You define your harms, you define your losses in this litigation.
The next question is, our home is still standing, but obviously damaged and surrounded by burn. What do you think the outcome of somebody in our position will be?
Yeah, it really depends on what your loss is, right? Your home is still standing. I don't know if it was damaged. I don't know if you're talking about exclusively smoke damage. Yeah, that's the kind of thing, and you're going to keep hearing that from me. It really depends. It depends on your facts and circumstances, right? And that goes back to this is not a class action. This is your lawsuit. It is your circumstances. It is your facts. So I can't give you a cookie cutter answer. I can just tell you it depends on what your harms are and what your losses are. And that's why you got to get on the phone with your legal representation and get help defining what those harms and losses are, and get educated on what your specific individual rights are. Whatever those harms and losses are, if they're caused by LADWP, then they're the ones to be held to account.
Does DWP have insurance?
Yes, so all municipalities, all cities, all counties have large pooled insurance trusts where they pool their own funds, and then above and beyond certain limits, there are insurance and reinsurance contracts to pay for the liabilities. So the short answer to your question is yes. And exactly how deep those insurance pools and the pooled funds go is a question that we get answers to during the discovery process. So concrete answers to that question are not too far in the offing here.
Now we have several questions that are all kind of around the same topic, which is folks are wondering, what are the costs of the retainer agreements? What, if any, costs will the victims be responsible for? How common is it for costs to be taken out before the 75-25 split? Do fees come out of gross recovery? So if you could just talk through some of kind of how does the fee breakdown go and costs?
So there are a couple of layers to answer that question. So there are the large overall, every single plaintiff benefits from the costs kind of cost. That is the experts to identify the cause of the fire, the origin of the fire, the spread of the fire, to gather the evidence, to retain the evidence, to analyze the evidence, all of those common costs. And those are actually shared across all of the law firms. All of us law firms are working together and sharing those costs. Earlier, you remember that Margot and I mentioned case management by the judge. In the Palisades fires, the court has entered a first case management order where the law firms are establishing a bank account, and the law firms will fund that bank account out of the law firm's own assets, right? This isn't from clients. This isn't from you guys, the victims. These are the law firm's own assets that are being put into a joint bank account to pay for all of those expert costs. Now, at the end of the case, when there's a recovery, if there's a recovery, those costs are recovered at cost. There's no profits being made by the law firms, by the attorneys, by anybody involved on those costs. Those are reimbursed through the recovery against the defendants. So those are the costs that are shared evenly across all of the people to prove why the fire happened, why the fire spread, who is culpable, and why it is that they're culpable. That's the way that those costs are incurred and reimbursed. Then at the individual level, the kinds of costs that you can anticipate are, so you need to put together your inventory, right? And you need to do the detailed whole house inventory. We have a vendor that we work with, and they charge about $1,400 probably for a typical home in the Palisades to do that valuation. That's a cost that we as a law firm will advance for you as our individual claimant on under most circumstances. And then at the end of the case, when and if there is a recovery, then we get reimbursed for that cost through that recovery. Then there are things like the filing fees. When we go to court, we incur costs for that. Our law firm advances that, and when and if there is a recovery, then we are reimbursed. We are reimbursed through that recovery for those costs. No one that's
From
watching.
the gross recovery?
Yes, of the total recovery is when there's a reimbursement out of that total recovery. Now, there was a question about what is the cost of the retainer. Nobody who's watching right now should be asked by any of the law firms that are representing them to advance any money towards the prosecution of the lawsuit. If you are, there are lots of other law firms out there that are not doing that. Lots of reputable law firms that are not doing that. I don't know of any firm that is charging an upfront retainer, but the way that question was phrased sounds like somebody has been told they need to pay an upfront retainer. If you have, ask why. Ask why is this not being charged by the other law firms? And then talk to other law firms and ask them, this is why I'm being charged for something. Are you doing the same thing? And if the answer is no, then you probably got a lot of information that's helpful to you on making your decisions about who should be representing you in this litigation. Margot, were there any parts of that question I dropped?
Oh, I don't know which one. Well, one thing we want to just remind everyone is if you have a retainer agreement already with a lawyer, you need to speak with them specifically about your agreement, and everyone has, different things in their contracts. So try and be mindful of that. If you have another lawyer, we're just answering kind of as to our agreements and our expectations in the field. All right, we do have a few other questions regarding the retainers though, so give me a moment. Some of the retainers mention special circumstances in which the plaintiffs or the victims could be responsible for costs. What are those circumstances?
Boy, that's a little bit out in the weeds, and that's kind of way down the road. So I'm a little bit hesitant to dig into that too much. Kind of the broad strokes on it. Number one is talk to your attorney. That's one. If you've gotten to the point of reading that in your retainer agreement, talk to your attorney. Long story short is that in California, we've got a statutory process to encourage settlement. And what it does is it has defendants, it encourages them to make settlement offers that are reasonable to the other side. And it also allows plaintiffs, meaning people like you who have been impacted by the fire, to make reasonable settlement demands to the other side. And one of the ways that it incentivizes the parties to settle is if you as a plaintiff make a reasonable settlement demand to the other side and they don't accept it at a time where there's enough information known for them to realize that liability is reasonably probable, then they have to pay your costs. Not your attorney's fees, but your costs, all the expert costs, the consultant costs, the filing fees, those kinds of things. They have to pay those costs back to you. On the other side of the equation, if once it has become reasonably apparent what the liability picture looks like, LADWP or whoever the defendants end up being can make a settlement offer to you. And if you do not accept it, and then you go to trial, and then you don't do better after trial, then they can recover their costs back against you. Again, it's the costs, not the attorney's fees. And keep in mind that this is not the right now situation. This is after all of those depositions that I talked about at the beginning of today happen. after you get through and get enough information. So you should have known better than to continue on your litigation in the face of this really reasonable settlement offer, right? It's supposed to, this is a statute that's designed to make people get serious about their evaluations, to get serious about discussing settlement. It's not a gotcha where LADWP or whoever else is responsible gets to make a lowball, silly settlement offer now, and you're out of luck if down the road, a year, 2 years down the road, the evidence ends up being against you. That's not the way that it works. That is an important statute. It is an important consideration anytime you're pursuing litigation, but there are many off-ramps for both sides. And this is the kind of thing that as you keep in regular contact with your attorneys, you will be evaluating this, and you will be in a place where long before you ever get exposed to these kinds of cost shifting or recovery circumstances, you will know that that's the road that you're going down, and you'll have plenty of chances to get off. This is certainly not the kind of thing that I would say run from litigation because that exists. This is the kind of thing I would say stay in touch with your attorney, understand your case as it's developing, so that you can have that conversation, have that level of comfort that I've had these 15 off ramps where I could get off, and I'm comfortable saying, no, I'm not getting off. I'm comfortable saying my attorney has kept me in the loop on the liability picture, and it makes sense to me to keep on going down the road. So don't run from litigation because these cost shifting statutes exist. There's a lot of misinformation out there, and I got to think it's coming from the folks who are responsible for causing these fires about cost shifting, trying to scare people away.
Thanks. And we're fortunate to have a lot of engagement from the audience and a lot of questions. So I'm going to be trying to group questions here, and we're going to do our best to get to as many as possible. So kind of the next category that maybe you can speak on, John, is can you speak regarding LADWP's immunities, your perception of the strength of the cases against LADWP, and if there are any downsides to filing against them if someone has adequate insurance?
If you had adequate insurance and you're fully reimbursed, the question is for what, right? And remember that we're talking about the inverse condemnation part, which is the plan to have inadequate water available during a heightened fire season. And then there is the second ignition utility cost. Adequate insurance will only cover you will only make the inverse condemnation part of the conversation easy to decide for you. The second ignition will address anything that's not personal property or real property. Again, your emotional distress, your quality of life, all that stuff. If you've been impacted by this fire, then you absolutely have emotional distress, stress, anxiety, loss of your community, the people that you've lived with all of your life. So from my perspective, absolutely, it would be worth it to pursue recovery of those rights, even if you had so-called adequate insurance.
What about the strength of the case against LADWP, and is there any concern they'll become insolvent?
Yeah, so the strength of the case against LADWP is what we determine with discovery. And anybody can become insolvent. We've seen GM go under. So I won't pretend that there is not some level of risk there, but you want to be in line to make sure that you can get as much of a recovery as you possibly can. We will be finding out through the discovery process what the layers of insurance are, what the layers of reinsurance are, what the self-insured pool looks like. So direct answers to your question, again, we'll get through the discovery process. Insolvency is always a very real risk when there's a huge catastrophe like this. But if you're not involved, if you're not pursuing your legal rights, whether they're insolvent or not, you're going to get no reimbursement, no recovery at all. It's best to be in line and engaged and involved to the extent that there's a recovery.
What about their immunities?
So the immunities, to me, Margot, it's one of these things where you're hearing a lot of almost psyops going on here. And what I mean by that is this is not a tort claim case. This is not under the government code. This is inverse condemnation. And the California Supreme Court, way back in 1972, said that these immunities have nothing to do with inverse condemnation. Right? It's the Baldwin versus State of California case. And that's California Supreme Court saying, hey, that whole Niehaus stuff and the contract stuff, that's all well and good when you're talking about a government code claim. That's got nothing to do with inverse condemnation, right? And then if, it's a second ignition for the utility, for the electrical utility, again, there's no immunity that applies to that. So don't fall victim to kind of the big talk, high talk, inside baseball talk of folks out there talking about immunities. Yes, there's a firefighter immunity. Yes, there's an immunity, if you could believe this, for fire hydrants not having enough water. But it's got nothing to do with the case when it's an inverse condemnation case or a strict liability for a utility, an electrical utility caused fire. Don't fall victim to that stuff. There's so much of it out there. It's really terrible, and it's got nothing to do with the case. That much we're confident of.
Can they just pass any assessed damages back to the ratepayers through rate increases?
So if I were to say no, that would be untrue, right? We've seen that PG&E up here, the utility up here, has managed to hold the legislator captive, and it's been allowed to recover a lot of these costs through increases in the rates. That's something that is a political question. That's something where the people of the state of California have to push back on the legislature, have to push back on the CPUC, and not allow that to happen. So that's another place where you've got to stay engaged. If people just shrug their shoulders and say, oh, well, then yeah, they will get away with that. The plaintiff's attorneys, the plaintiff bar fought hard against the ability to pass on those kinds of expenses through increased utilities. Sometimes you don't win every fight, but if it matters to you, stay engaged, not just with this litigation, but politically. When you have an opportunity to meet your representative, ask them this question. Ask them, what are you doing to make it so they can't do that? Because it's your representative who can do something about that. And they should also be asked that tough question. And they should also give you an answer to that question.
Is payout first to join, first to be paid out?
No. We don't know what the ultimate structure is going to be. If we go through that entire litigation process, that timeline, that discovery, all that stuff, and we get to the end and there is going to be a recovery, we don't know how that's going to be structured. But what we do know universally across all of the other fires, it's not first in, first out. It is structured and it is put together in a way to be fair to as many people as possible. So getting in early doesn't ensure that you're going to be first in line to get paid. Getting in early does ensure that you have your paperwork in, that when it comes time to start issuing payments, that your paperwork is in, your damages are established. There is no more I to dot, T to cross before you can get paid. So there is a get in early, do your homework, prove up your side of the case, get compensated sooner aspect to the case, but it's not first lawsuit to be filed, first person to get paid. It's not first law firm that files a lawsuit, first law firm's set of clients to get paid circumstance. That way it does not work.
And that kind of is a good segue into some of the other kind of threads of questions we're seeing, which is this a mass tort? Is each firm going to work independently, combined? How are the costs divvied up among the plaintiffs in the litigation?
Yeah, so I'll go back to the case management order that was just entered in this case. So there's a plaintiff steering committee that is appointed. And what that does is that acts as an administrative arm to help coordinate on the plaintiff side of the equation. It helps coordinate all of these different law firms that have a common interest, right? All of us have the common interest of proving the case, establishing what the causes of the fire are, proving liability so that we can then move on to step number 2, which is getting our individual clients compensated. So there is the administrative apparatus put in place, the plaintiff steering committee. Being on that steering committee, contrary to some of the other information that's out there, that does not get any of the clients represented by those law firms special benefits, special privileges. The law firms that are on the steering committee do not get special compensation. They are purely an administrative arm that is appointed in all of these large scale cases, all of these large fire cases, to help smooth the administrative process of getting information from the defense, of getting an agreement from the plaintiff side of the equation, what kind of deadlines we're setting for the defense to provide information to us. So within that administrative arm, the steering committee, we coordinate. We not only coordinate getting information from the other side, but we also break apart or crowdsource the discovery. Right, within the plaintiff's law firms, we agree this guy's going to do this, that guy's going to do that. And those of us who have been involved in this previously and have developed some level of understanding and skill in these things take on specific tasks. And by crowdsourcing the work like that, that's how you're really able to expedite and get these kinds of cases discovered and move forward a lot faster. So there's coordination amongst all of the plaintiff's law firms to get the liability part of the case proved up. Earlier, I talked about the costs, the common interest cost, all of the expert costs of proving liability and how that's reimbursed. So I won't go back into that. But there's the liability part where we all have a common interest and we all coordinate. And then there's the damages part, your individual loss. And that's where we're now working one-on-one with our individual clients and putting together the answers to the questionnaires about your individual losses and proving your individual losses. And that's where it pays to be with a law firm that doesn't have 4, 5, 7, 8, 10,000 clients, because how are they going to pay individualized attention to that many clients? We're not taking on that many clients. We know.
Why not?
We know that we can't do what needs to be done for each individual client, right? Having been through this and knowing the level of attention to detail that's required, I can't do that. Nobody can do that for 10,000 clients. It's just simply not possible, which is, why it's a good thing that there are so many different plaintiff law firms involved, because the work can be spread to people. It can be spread so it can be done properly. But there's that cautionary tale of, if last week all you did was car accidents and slip and falls, and today you're doing Palisades fire or Eaton fire litigation, do you really know what you're doing? Are you really going to be able to deliver the product that you're promising, this level of service that you're promising? So as I've said in each one of these webinars in the past, and I'll say again tonight, talk to the law firm that you're considering, talk to the law firms that you're considering having represent you, make sure you like them, that you can contact them, that you trust them. When you talk to them on the phone, that you don't get that weird sense of, I'm not sure these guys are on the up and up. Because if you can't trust them, you're only going to end up even more unhappy in the end. You've been through enough. Listen to that sixth sense. Make sure that somebody you trusts the law firm that you're going to work with. So that's how costs are shared. That's how the cases are worked up. And that's why it's important that you work with somebody who can pay attention to you as an individual, and not just gather mass thousands of people and not realistically be able to help you.
We do have a lot of questions here. So John and I will stand and try and type in answers to some of these in a minute. But before we end the session, some people are wondering, who do they contact? How do they reach out if they have follow-up questions, or if they want to get in touch with you, John?
Yeah, let me pull. So many of you know Mychal, and Mychal has connected many of you with my law firm. Our website is cutterlaw.com. I'm pulling up right now our website graphic so you can take a screenshot of it. I'm going to put it up and share it here in a moment.
And I'll sit here and try and answer some of these in typed. Or if John, are you able to stay on? I don't know if you're free.
Yeah, I can stay on for about another. Well, Margot, why don't we just stay on for the next 10 minutes? I've got to leave after that. But
Okay.
Why don't we stay on for the next 10 minutes and just go
I'll just
ahead.
try and quickly crank through some of these if that works. Okay.
Okay.
How do you calculate damages beyond the amount of loss of personal property?
So you've got, look around what used to be your home, right? You've got personal property, everything that's in the home. You've got the real property, the home itself. And then you have the harms to you as an individual. The annoyance, the angst, the anxiety, the loss of your community. All of those are different elements of loss, as are the additional living expenses that you are going to incur, that you are incurring from this, from the day of the fire on forward. That's part of what we do all the, day in and day out. That's part of what juries decide day in and day out in courtrooms all across the country. And so while it feels daunting as the person who has been impacted, that is something that we can help you with. And Margot, while we're answering these questions, I'm going to put up the graphic that I promised with our contact information.
Okay. Is your firm connected to Kevin Boyle's suit? If not, what is the difference between your suit and theirs? Can residents join more than one lawsuit?
I'll take those questions in reverse order. You can have only one lawsuit pending, period. And you can have one law firm representing you, although that law firm may be working with other law firms. We are not working with Mr. Boyle's law firm. We are not part of that lawsuit. The harms and losses, or rather the theories of liability, I should say. I understand that the Boyle lawsuit is inverse condemnation only, but they may well be investigating other causes. I don't know. I don't know their process or what their theories are.
What percentage of a settlement or judgment do you take? Does that include your fees? I'm assuming that means costs.
Yeah, our law firm is working on a 25% contingency fee. That means if there's a recovery, the recovery is 25% of that recovery. And by recovery, I mean against people responsible for causing the fire. We explicitly, in our retainer agreement, disclaim any money that you're going to get from your insurance company, unless we have to file a separate lawsuit against the insurance company for abusive claims tactics.
If I've already filled out an intake form with another firm, will this affect me or will be swept into one firm? I was confused about this and I'm already now doing an inventory.
Yeah, that is a very good question. Very often people will do exactly what they should do. Call multiple law firms, talk to multiple law firms, get an understanding and a comfort level after having had multiple conversations with multiple law firms or going to multiple webinars. And you remain free to seek representation from whatever law firm you want. It's important that you kind of pay attention to what's going on. I've heard stories of law firms using sneaky tactics that you think you're just filling out an intake form, and then next thing you know, this retainer agreement shows up and supposedly they're representing you. I've heard sneaky stories like that. I would have hoped that they're not true, but from the number of times that I've heard it, it must be.
Can you get out of the law firm if you've signed an intake form?
Yes, absolutely. Call them, ask them, who do I need to write to and what do I need to say to terminate your representation? I do not want to be represented by your law firm. Be active on that, right? You want to put it in writing, get it from them, talk to whoever's answering the phone, talk to whoever your contact is, and then put it in writing. Make it clear, right? You don't want somebody claiming to represent you when they don't, but put it in writing.
Can getting legal representation affect your insurance payout?
I'm not sure I understand what the question is, but let's put it like this. Your insurance company is not allowed to retaliate against you for getting legal representation. They cannot retaliate against you for getting legal representation to help you with your insurance claim. They cannot retaliate against you for pursuing a lawsuit against whoever's responsible for causing the fire. So if that's what you mean, absolutely, positively, no.
Do you work with the victims and public adjusters?
We represent victims. So yes, the answer to that question is yes, absolutely. We work with fire victims. Do we work with public adjusters? Some of our clients do hire public adjusters. I'm not sure that it's necessary for most of our clients. We talk to lots of folks who have hired public adjusters and they're happy with it. So be it. I'm not sure it's necessary, especially in a circumstance where you are underinsured. But we're happy to talk with you about your circumstances and whether a public adjuster is something that's helpful or useful for you.
Must folks join, or is everyone from the affected areas entitled to receive judgments or settlements?
You must. Let me be perfectly clear. You must join a lawsuit. You must act soon because there are statutes of limitations that block you and forever prohibit you from making a recovery if you don't hit them, right? Now remember, you're suing the government. The government writes the laws. The government writes the laws in a way that are beneficial to the government, not to you as the person that's been harmed by the government. Those timelines are short. And you want to make sure you get in, you talk to an attorney, you do what you need to do to hit those timelines. Just by being a victim of the fires does not mean that your legal rights are protected. You must take affirmative steps to protect your legal rights. And that does mean filing a lawsuit and taking the steps necessary so that you can, in fact, file a lawsuit.
What is the fee split?
Yeah, that's the same thing we've been talking about before, and that's the 25% contingency fee. That means if there is a recovery, our fee is 25% of that recovery against those responsible for causing the fire, not your insurance company, but those responsible for causing the fire.
What is the deadline for the statute?
That's something that I want to talk to you on an individual basis about. That's a little bit too far into the legal advice, and I don't want anybody to misunderstand because that is way too important. Act now. That's the best that I can tell you.
Okay, sorry. The questions are still pouring in, so please feel free to reach out to us if you have more questions. We haven't answered them. Some of them are more specific, so I'm trying to answer the ones that apply to everyone first. Would this be a case against the city or county or state?
So at this point in time, it is looking like it is the city of LA through the Department of Water and Power that is the primary culprit.
Can you explain inverse condemnation?
Sure. Inverse condemnation in its simplest form is part of the California Constitution, and it just means that the government can't take your property without paying just compensation. And when the government acts, it puts into a place a policy such as taking the Santa Ynez offline so that there is not sufficient water. It makes a deliberate policy decision to do that. And that deliberate policy decision results in the taking of your property through fire. It must therefore pay you just compensation for the destruction of your property.
I have heard that plaintiffs are being broken up into groups of 25 that file together. Why is that?
I can't say I've heard that one, and it may make certain sense for the law firms as as a business decision, but I can't speak to that particular.
That's going to be an individual law firm choice to do that.
Yeah, probably.
If there is a settlement of personal properties, are they evaluated based on replacement cost or what was the cost 10 to 20 years ago?
It's going to be the fair market value at the time of destruction. If what you're talking about is a recovery against those responsible for causing the fire. When it comes to your insurance, that most people have an actual replacement cost, meaning today you go out and you buy the thing. That's what your harm is. That's what your insurance company will pay. But when it comes to those responsible for causing the fires, it's the fair market value at the time of the destruction.
And it's important to note, and our firm was really critical and involved in making the law that created this. Let's say you have a couch in the very front room of your house that's pristine and untouched. That couch is worth more than my couch, which has kids and pets and everything climbing all over it for years. So it's the state of your property individually, not just the age of it. And our firm was involved in litigation for years to make that a reality for folks.
Yeah, and that's one of the things we talked about in some of the other webinars there, Margot. The case that you're referring to is that State Farm case where State Farm was not paying people fair market value. They were treating everything universally as essentially as junk. Your father, my business partner, Brooks Cutter, was instrumental for 10 years chasing that lawsuit and getting a fair result for policyholders in the state.
If the essence of the lawsuit claim is different between different law firms, how can we select which firm and which lawsuit to become a part of if we don't have an in-depth legal understanding of nuances?
Ask the law firms that you're considering, right? That's what we've been talking about here tonight is that there are two paths. There's inverse condemnation, and then there is the second utility cause. And so see if the other firms that you're evaluating can answer that question for you, can explain that to you in a way that makes sense to you. If they can't, then that's something that you should definitely evaluate in deciding who to work with.
Okay, I think we do have to call it for the night. We do have some outstanding questions. So please feel free to contact us individually, and we're happy to do our best to answer your questions. Otherwise, I think Michael will be notifying people of future webinars. Is that
Yeah.
the case? Okay.
Yeah,
Well,
and send us an email at wildfire@cutterlaw.com and set up an appointment if you want to talk further, if you want to get additional questions answered. We've held dozens and dozens and dozens of meetings. So reach out. There's also 888-285-3333. We can set a phone conversation to meet as well.
Michael had a family emergency tonight, but I'm sure he'll be on next time. And thank you all for attending. Thanks, John.
Thank you, Margot. Thank you, Michael.
Bye.